Hi, everyone. On behalf of HR.com, we welcome you to the webcast, Essential Health Benefits, Importation, and More. Do you know the risks? This is sponsored by Aimed Alliance. It has been pre-approved for one HRCI and one SHRM credit, so please be sure to attend the complete webcast in order to receive your credits. They will appear in your HR.com account within 2 business days, and then we'll also send you an email with your credit information. So during the webcast, if you have questions for the presenters, we ask that you put questions in the Q&A in your webinar controls. We also have the chat open for some engagement, and I think that's all of the logistics. Without further ado, it is my pleasure to pass it over to you, Ashira Vantries.
Hi, everyone. Good morning or good afternoon, depending on where you are. My name is Ashira Vantries, and I'm counsel at Aimed Alliance. If you're not familiar with Aimed Alliance, we're a nonprofit health policy organization, and our mission is to protect and enhance the rights of healthcare consumers and providers. And so one of the ways that we do that is through conducting legal research and analysis on insurer practices, and really all healthcare industry stakeholder practices to identify where there is compliance or inconsistencies with the law and its application, and identify opportunities to engage stakeholders to ensure better compliance with the law. So I'm thrilled to have on the call with me today, Dr. Feldman, who's with the Coalition of State Rheumatologists. And Dr. Feldman will be talking about her experience with these non-EHB or essential health benefit programs, and why these programs are concerning to her from a provider perspective. Dr. Feldman, would you just like to pop on and say a quick hello and maybe provide a little bit of information about your organization?
I can do that. Well, here I am. Hi. Yes, I'm a practicing rheumatologist, but the Coalition of State Rheumatology Organizations is essentially a coalition of societies, rheumatologists, and our primary mission is to advocate for excellence in rheumatic disease care.
Great, thank you so much. Colette, I next want to introduce Colette, who is with the National Hemophilia Foundation, and she's the VP of Payer Relations. And Colette's going to be talking with us about how she's seen personally with these programs impacting patients, and how she's helped patients navigate those programs. Colette, do you just want to say a quick hello and introduce NHF? Oh, you're muted.
Sorry, guys. Colette Kolianis. I am with the National Hemophilia Foundation and have been for 7 years. National Hemophilia Foundation is dedicated to helping find cures for persons with hemophilia or other inherited blood disorders. And we have been working diligently on these access barrier issues that you're going to be talking about today, or we're going to be talking about, and I thank you for your time and attention.
Thanks, Colette. Just so we're all on the same page of how this webinar will continue, I'm going to provide a brief background on copay accumulators and how they've evolved into non-essential health benefit and alternative funding programs. And then I'm going to discuss some of the ways that we at Aimed Alliance find that these programs might be inconsistent with different areas of law. And then we're going to hear from Dr. Feldman, providing the provider perspective. And then we're going to hear from Colette on her experience working with patients in these programs. And then we'll open it up for a Q&A at the end for about 5 to 10 minutes. So if you have any questions throughout the webinar, please feel free to put them in the Q&A or in the chat, and we'll do our best to address them at the end. Okay, before I jump into my portion of the presentation, I want to say that while I am an attorney, I am not your attorney. So while I will be discussing certain laws and how we understand them at Aimed Alliance to be applying to some of these programs, this is not legal advice by any means. So please consult your counsel before you make any decisions on these programs. This is simply intended to be informative. But with that, I'll just jump right into it. So to properly understand what we're going to be talking about in terms of non-essential health benefit programs and alternative funding programs, I think it's really important to trace back to how these all started with copay accumulators and maximizers, and really how copay accumulators and maximizers targeted third-party assistance. So third-party assistance is assistance that patients use when they can't afford their medications because they can't meet their cost-sharing requirements. And so this assistance can come in a variety of forms. You might have heard of it as manufacturer copay assistance, but it also comes in the form of charitable assistance and other nonprofit support. So typically this assistance was not only helping patients afford their medications at the pharmacy counter, but it was also helping them reach their deductible and annual out-of-pocket limits. But health plans started adopting copay accumulator programs, which accept the third-party assistance towards meeting the cost of the medication at the pharmacy counter, but don't count the assistance towards meeting the patient's deductible and annual out-of-pocket limit. So essentially, it only gives the patient half of the benefit of this type of assistance. And I just wanted to flag there's also another type of copay accumulator program that we're probably going to be talking about throughout this webinar. So a copay maximizer, it's a type of copay accumulator, but under a copay maximizer, the plan inflates the copay to the maximum amount of assistance available. And so what they do is they identify how much assistance is available over 12 months, divide that by 12 and set that to the monthly copay. So for example, if there was a maximum of $1,200 available for the entire year, that divided by 12 would be $100. So the monthly copay would be set to $100. And that's typically how we've seen copay maximizers, but there are some deviations to how that works. But I think copay accumulators and how those programs started collecting third-party assistance and not counting it towards the patient's deductible and annual out-of-pocket limit are important, as they're really kind of the foundation for what we now see as the non-essential health benefit program. So really the next step of copay accumulators. So under a non-essential health benefit program, a health plan will partner with a third-party company to manage their specialty medications. And then that third-party company will say that specialty medications are considered non-essential health benefits. So as a result of defining these medications as non-essential health benefits, the third-party program can then say that these medications are not subject to any annual limits on cost sharing. So from the beneficiary's perspective, what happens for them is that when they try and fill their specialty medication, they're contacted by this third-party program that the health plan has partnered with. Some of the bigger names are Save on SP and Prudent RX. And they're told that they have to enroll in this third-party program in order to access their medication. And if they enroll, they'll have a low copay between $0 to $5. But if they don't want to enroll, then they'll be subject to a copay of between 30% to 70%, depending on the program that their health plan has partnered with. And that coinsurance is not going to count towards their deductible or annual out-of-pocket maximum. So it essentially puts patients in a position where they have no option but to enroll in this third-party program in order to access their medication. And then once they're enrolled in the program, it's operating like a copay accumulator. So it's accepting the assistance from a third party, typically manufacturer copay assistance, and it's not counting that assistance towards meeting the patient's deductible or annual out-of-pocket limit. The next step of programs that we see are what we call alternative funding schemes or alternative funding programs. And they're similar to the non-EHB programs in that they both rely on the same legal justification. So they both say that specialty drugs are considered non-essential health benefits. But the difference between alternative funding schemes and non-essential health benefit schemes is that while non-essential health benefit schemes primarily target manufacturer copay assistance, alternative funding schemes target a broader array of assistance programs. So they look at manufacturer copay assistance, charitable assistance, and they also look at importation from outside the United States. So under an alternative funding program, just like the non-EHB, there's a third-party company that's partnering with the health plan to manage the specialty medications. But under an alternative funding program, what happens is that when the patient tries to fill their medication, it'll automatically be denied for coverage by the plan. And then this third-party program, the alternative funding program, will get involved and work with the patient to determine if they're eligible for any of these alternative funding sources to get their medication. And if they're not eligible for any alternative funding sources, the medication will go back to the plan and be covered like a regular pharmacy benefit. And so this is just an FAQ that I have from an alternative funding program that really just walks you through how this program works. And these slides will be available after the webinar, so you can go back and look at this in more detail. But it says essentially what I just explained, that when a patient tries to fill their prescription, it's automatically denied. If it meets the criteria for this alternative funding program, the patient is put in contact with the alternative funding program, who then helps enroll the patient in alternative funding sources, whether that be manufacturer copay assistance, charitable assistance programs, which are often income dependent and require your health plan to not cover it in the first place, which is why they have to do that upfront denial, or importation. But like I said, if you're not able to get your medication through any of those alternative sources, then the medication goes back to the plan and it's covered like a regular pharmacy benefit. And these programs are typically structured just like the non-EHB programs. So they basically place patients in a position where they have no option but to enroll in the alternative funding program because they're using that non-EHB definition. So this is an example from an alternative funding program that I pulled. And it says, if you do not apply or you choose not to enroll, you'll be responsible for the full cost of your applicable specialty drug, which will not count towards your annual out-of-pocket maximum. Again, placing patients in this position where you have to pay an infinite amount for your medication or enroll in this program. And obviously for patients, it's not feasible to pay an infinite amount really for anyone for their medication. So they have no option but to enroll in the alternative funding program and have their medication potentially sourced from other means. So I know that's kind of a lot of information, but I think it's important to kind of have that understanding of how these programs are working before I talk about these 3 areas of law that we at Aimed Alliance see could be potentially violated by these programs. So first, I'm going to talk about the Affordable Care Act and the essential health benefit requirements. So this specifically applies to both non-EHB, non-essential health benefit, and alternative funding programs, because they both use that non-EHB definition to, create their programs and that coercive scheme where patients have no option but to enroll in the program. So as many of you are probably already familiar, the Patient Protection Affordable Care Act, also known as the ACA, it requires that plans cover 10 essential health benefits. And these coverage requirements apply to individual and small group plans and large group plans that voluntarily choose to cover essential health benefits. So of the 10 essential health benefits, one of them is prescription drugs. And the reason this designation as an essential health benefit is important is because under the ACA, it says that any amount the patient pays towards an essential health benefit has to be counted towards meeting their annual out-of-pocket limits. So when these non-EHB and alternative funding programs say that patients could be subject to a 30% to 100% coinsurance, or for 100% of the cost of the medication, and that's not going to count towards their annual out-of-pocket limits, if that medication was considered an essential health benefit, it would violate this requirement under the ACA. And so these programs attempt to avert that requirement by defining these medications as non-essential health benefits. And they use 2 arguments to justify how these medications can be considered non-essential health benefits. So the first one is they argue that they are permitted to carve out specialty drugs from the definition of prescription drugs as an essential health benefit. And the second way is they argue that they're only required to cover the minimum number of drugs in a therapeutic class or category, and anything in addition is considered a non-essential health benefit. But from our view at Aimed Alliance, both of these justifications are inconsistent with the ACA and its implementing guidance issued by HHS. So looking at both these arguments individually, the first argument that we see is that these programs are permitted to exclude specialty drugs from the definition of prescription drugs as an essential health benefit. And so HHS has said that while plans are permitted to create their own definition of an essential health benefit, it has to comply with HHS's approved guidance and regulations. And so far, HHS has only created 2 narrow carve-outs from what can be excluded from the definition of a prescription drug. And that's for brand name medications that have a generic alternative and medications that are used for abortion. And so we know from the work Ames Alliance has done with Colette at the National Hemophilia Foundation that over 90% of the medications that are on these non-essential health benefit programs are brand name medications that do not have generic alternatives, and they're not medications used for abortion. So essentially, this carve out could not apply to these non-essential health benefit programs, which means that they are using a definition of prescription drugs as an essential health benefit that's inconsistent with the ACA. So that's one way these programs could be potentially violating the ACA. The second way is through these programs arguing that they're only required to cover the minimum number of drugs in a class or category, and anything in addition is considered a non-essential health benefit. So under guidance from HHS, they've said that for individual and small group plans, all drugs in addition to the minimum number of drugs in a category, when they're determined to be medically necessary for the patient, they have to be treated like an essential health benefit. And so under that understanding, all additional medical, under that understanding, that minimum coverage requirement is really intended to be a floor, not a ceiling like these plans are trying to, or these programs, excuse me, are trying to argue it is. And while there is not explicit guidance from HHS on how this applies to large group plans, there is guidance from HHS that says that when a large group plan voluntarily chooses to cover an essential health benefit, it has to comply with HHS's guidance on essential health benefits, which from our understanding at Ames Alliance would include treating this minimum coverage requirement as a floor and not a ceiling, and treating all medically necessary medications as essential health benefits. So that's our understanding of how the non-EHP program could be inconsistent with the ACA's essential health benefit requirements. Next, I want to talk about the alternative funding programs and their use of importation. So as you guys probably recall, the alternative funding programs, once that medication is denied and the patient is connected to the alternative funding program, they can source the medication from a variety of ways, and one of them is importation. So the FDA's guidance has said that it's illegal for individuals to import drugs or devices into the US for personal use because these products have not been approved by the FDA. So the general rule of thumb is that medications cannot be imported from outside the United States. FDA does have two exceptions to that general rule, the personal importation policy and the importation of drugs originally intended for foreign markets, but really neither of those two exceptions would apply to the alternative funding programs. So looking at each of those exceptions, under the personal importation policy, an individual is permitted to import medication from Canada, not any other place other than Canada. It's narrowed to Canada. And they can import medication if it's medication that's not for a serious condition. So this is like over-the-counter medication that we might not have in the United States, or for a serious condition when the product is not available in the United States. As long as it wasn't promoted to the individual, it doesn't impose an unreasonable risk, and the consumer affirms it's for personal use and is not more than a 3-month supply. So I think from this guidance that FDA has issued, it demonstrates that this really is intended to be a personal importation policy for an individual, and it's not intended to be used as a means of having an entire plan access medication from importation and be safeguarded by this policy. So the next exception that FDA has created is for importation of drugs originally intended for foreign markets. So again, this exception is very narrow in its scope. It's for Canadian importation only, and is for states and Indian tribes, and they're required to submit a proposal to the FDA. And the reason I wanted to flag this one is because I think it's important to address it, because while obviously these third-party programs are not likely to be states and Indian tribes, even if they were to use this justification under this guidance, there is a large limitation on what can be imported. So even under this exception, states and Indian tribes are still not permitted to import controlled substances, biologic products, infused drugs, intravenous drugs, intraocular drugs, REMS treatments. So it's still very limited in scope. And so I think that's really important to acknowledge that. Again, these alternative funding programs, they're not going to likely classify as a state or an Indian tribe. So they couldn't qualify under this exception. And even if they did, they would be subject to these limitations. But from our understanding, we can't understand a way where they would be able to operate under either of these two programs. So this could mean that these programs are illegally importing medications in violation of FDA guidance, which could potentially mean that the FDA could take enforcement action against these programs, and enforcement action can come in a variety of means. So it could come in something like a warning letter, or it could be something more severe like civil and criminal penalties. So the next area of law that I want to talk about is alternative funding programs and ERISA. So with the alternative funding programs, one of the things that they target is charitable assistance programs. So the problem with targeting charitable assistance programs, other than it's not the intent of those programs, is that it essentially creates two categories of benefits for plan enrollees. It creates one category of benefits for low-income employees and a second category of benefits for high-income employees. And the reason that it does that is because if a plan has, let's say, two employees who have the exact same condition, and they're paying the same premium, and one of the employees tries to get their medication, they're eligible for the alternative funding program, and the alternative funding program sends them to a charitable assistance program, and they only make $25,000. So they're going to qualify to get their medication under that charitable assistance program. So they'll get their medication through that source for the entirety of the year. Now, another employee who has the exact same medical condition, same employer, same everything as the first employee, but makes $125,000 a year, when they apply to the charitable assistance program, let's say they're denied because their income is too high, and they're not eligible for any alternative funding sources, then their medication is going to go back to the plan and be covered like a regular pharmacy benefit. So it's essentially creating this scenario where your lower income employees are getting their medication through a charitable assistance program, and your higher income employees are getting their medications covered like a regular pharmacy benefit. So this separation of benefits between lower income and higher income employees could potentially violate IRS Code Section 105H, which prohibits plans from discriminating between highly compensated individuals and other employees. And that's essentially what's happening here, is that the lower income employees have to get their benefits from one way, whereas the higher income employees are getting their benefits another way. So this could be another potential violation of the law in the alternative funding programs. The last thing that I wanted to flag is just another way these programs could potentially cause legal interventions. So in this past summer of 2022, Johnson & Johnson sued a non-essential health benefit program known as Save on SP. And in their complaint, they alleged that the Save on SP program tortiously interfered with their contract and engaged in deceptive trade practices in violation of New York law. So this litigation is obviously still ongoing, and there hasn't been an outcome of it yet, but just highlighting it as another reason to avoid these programs and potential other legal implications that they could cause. So I know that was a lot of information that I gave everyone, but I hope it was helpful background to understand these programs and the legal areas that their conduct could be inconsistent with. But now I want to turn it over to Dr. Feldman so she can discuss how these programs impact patients and providers and why, from her perspective, they are concerning. Dr. Feldman?
Thank you so much, Ashira. That was a lot of information, a lot of great information, I think, to help employers understand the pitfalls of engaging with these kinds of programs. So I'm a rheumatologist. That means I treat patients with everything from tennis elbow to severe lupus. Most of my patients, though, however, fall under what's known as inflammatory arthritis. It's arthritis that's caused by the immune system. So rheumatoid arthritis, psoriatic arthritis, various kinds of ankylosing spondylitis, arthritis associated with inflammatory bowel disease. And if you are an employer and you have any employees that have these conditions, you know that these conditions, the medications that we use, often can be extremely expensive. So maybe while, the rheumatology patients with inflammatory arthritis, for example, rheumatoid is maybe 1% of the population, it has been shown to perhaps be as much as 20% of our national drug spend. So these are very expensive medications. So consequently, they can be very expensive for self-funded employers. So we've been very sensitive to this. And when I have patients that are in self-funded, as with all of our patients, we use the least expensive medicines that do the trick. And when those don't work, we have to move on to either biologic medications or targeted disease modifying, all of which can cost $70,000, $80,000, $90,000 a year. So how I first came across the first program that was talked about in terms of maximizers, this was back in 2017, 2018. One of my patients came to me with this letter from the insurance company saying that the drug that you're taking is not an essential drug. Therefore, any money that you pay towards it does not count towards your out-of-pocket or your deductible, but sign up for our handy dandy, and it happened to be Save on SV program. Well, and she was scared. She thought she was losing access. She said, I can't afford this. And then what I found out later was actually she could have used her copay card and gotten the same kind of benefit that she would have gotten, from signing up for the Save on SP, but they didn't tell her that. They made it seem as though she had to sign up for this program. And then once she signed up for the program and turned a copay assistance card, because if you're, responsible for 20% of the cost of the drug, you're not going to be able to afford that if, the drug's $70,000 a year. And then at that point, what it seemed like was if her cost share maybe for that year was $10,000 and the copay card was worth $20,000, the entire copay card was exhausted. And at least back then, what they did was, as long as there was money left on the copay card, they started increasing her cost share over that plan year. And that aspect of it is important because, first off, when we talk about the next one that I came across were the alternative funders, but as you can see, this starts draining more and more in terms of assistance. And what we're afraid of is that essentially the qualifications for this assistance is going to become so narrow that our patients are not even going to qualify for the assistance. So one of the things that the Coalition of State Rheumatology Organizations is involved with is model language for various kinds of utilization management tools, whether it's step therapy, things like that. So one of the things in terms of state legislation that we've looked at includes that the insurer can't change the cost share for the patient or the plan benefit over that year. So that's sort of how we got involved with all of these plans. And as far as the alternative funders, I came across this as president of CSRO. We have rheumatologists from around the country sending us questions, sending us issues, sending us all kinds of problems they've had with getting access for their patients to medications. They weren't sure if the medication they were receiving was actually imported or not imported. So we started at the same time this was coming across while we were trying to put together an employer toolkit to talk about the importance of maintaining disease stability in patients with rheumatoid arthritis and how taking care of the disease was important and could save you money in the long run. So all of these things sort of came to us at the same time. And when we started looking for ways that might help save employers money for the kinds of medications we treat, we were actually approached by one of these alternative funders, or at least someone representing them, to show us how they worked. And when we started looking into it, we realized that we maybe didn't know where the medication was coming from. Sometimes they would carve out, as Ashira was talking about, the so-called non-essential benefits or non-essential drugs. and I still remember looking at that list of, Herceptin, a woman with breast cancer, thinking that Herceptin was not essential. The whole idea of non-essential drugs, particularly these drugs, it should be illegal. And I think Ashira went through some prime examples of how it really is sort of a misinterpretation of the ACA. But nonetheless, we started seeing how these plans worked and realized this was probably not only not ethical, but probably illegal, and started looking into and taking a look at how we could prove that they were actually bringing drugs in from other countries. So I do have a few slides, and I can show you some of the things that if you want to set up the first slide, this actually came from patient information from Sharps. And basically it says that we started working with your company, and there are certain medicines that we can source. And by the way, those aren't going to be covered by your health plan, but don't worry, we can get you these medications for free. It all sounds fine and dandy. However, go to the next slide. It says many of these medications come from Canada. So right there and then, it did not meet any of the criteria that would qualify either a state. They're not a state, they're not an Indian tribe, and these are for serious medical conditions. So they don't meet the FDA exceptions for importation right off the bat. And then it said for overseas orders, it can take 4 to 5 weeks. So we're talking beyond Canada. So I can tell you, if I receive a drug that has a foreign name on it and does not have proof that it was sourced from a manufacturer here in the United States, I will not give that drug to the patient. So here the patient and the employer has paid this company to source this drug, and you're not going to find a physician that is going to give an imported drug like that to the patient. So everyone loses. The employer loses, the patient loses. Next slide, please. This is another example of, I suppose they're just being very upfront about this importation because they must feel as though it's legal. But you can see on the left is a contract between Sharks and a school district. And they very clearly in the contract talk about importing medications from outside of the United States. And they're calling it the Borders Program. Here are 2 other alternative funders. One is RX Free for Me. And I don't know if you can read it, but in the print, it says we also help facilitate medications dispensed both domestically and from Canada. And then yet another one, they went through a list of medications that are essentially rheumatology medications. And this one here, Cimzia, is used to treat rheumatoid arthritis, psoriasis, psoriatic arthritis, and inflammatory bowel disease. And they have IPP there showing that they actually import it from foreign sources. I think I have one more slide. And this, I put arrows next to the drugs that are imported, but there are so many other ones. I mean, you can see where the type of assistance was approved. And you can see that if they obtained a copay card for the patient, and you follow it all the way over to the second to last column, you can see how much they charge the employer for obtaining a copay card. So one of the things that I want to let you know is that the physicians who prescribe these drugs, we do this for free. We get copay cards for our patients for free. We apply to the medical assistance programs. For Medicare patients, we apply to the foundations. We get them free drug. It's sent directly to their house. And it costs, at least for those non-Medicare patients, the employer $0. So several things make this very, I'm very leery about this. Number one, it's costing an employer to get assistance for patients that the physician does for free. Its sources from unknown areas, and therefore the physician probably won't even allow the patient to take that drug, particularly if it's a biologic or any type of complex medication, at least for the diseases that I treat. And number four, it's, no one feels sorry for the health insurance companies or manufacturers because of the deep pockets. But I can tell you, as these programs have come into existence, it's becoming more and more difficult for my patients to get the assistance. So I think one of the things we're worried about is that the assistance will gradually become so difficult. Many patients who used to be able to qualify for these programs, they'll no longer qualify. And if these diseases are not treated, the most expensive disease is the untreated disease. And for the diseases that I treat, like rheumatoid arthritis, if that disease is not controlled, we see malignancies, we see heart attacks, we see joint replacements, which in the long run end up costing the employer a lot more. So these are very, very concerning, makes it difficult for me to treat these patients. And this information really needs to be widely known by employers to really take a sharp look at what's being presented to them, what seems like easy money up front. And I'll be happy to answer any questions at the end.
Thanks so much, Dr. Feldman. I think that was really helpful in really providing that real world perspective. Like, you're on the ground, you're treating these patients, you're seeing exactly how these programs are working. So thank you so much for sharing your insights. Next, I want to turn it to Colette Koulianos with the National Hemophilia Foundation to discuss her experience working with patients and helping them navigate these programs. Colette.
Thank you so much, Ashira. I appreciate, again, you having me here today. So if we would just switch to the first slide. And I want to talk just basically, I understand, depending on who the audience is on the call today, if you're an employer, I understand that the top strategy for you is managing high cost claimants. And I also understand that the patients that we represent at the National Hemophilia Foundation are high cost claimants. If you happen to have one of our patients on as a beneficiary in your plan, I didn't have to tell you that. But there are only 30,000 total patients in the country that have one form of hemophilia or the other. So you may not have any on your plan, but this is a strategy and everyone's focus is on high cost claimants. And so because when 1.2% or so of your beneficiaries account for sometimes 50% of your spend or more, depending on what data you look at, I understand why you focus on that. The problem is with a lot of these programs that are being applied as a one size fits all, there are certainly unintended consequences to patients. And that's what I'm going to try to discuss here. Next slide. So let's start with just some fundamental truths. Out-of-pocket costs are exorbitant for people today. Over 80% of commercial enrollees have a deductible. Now that deductible can be a couple $100, but it can be all the way up to the max out-of-pocket, which in 2023 is going to be $9,100 for an individual, or double that for a family. So if it's considered a high deductible, that would be any plan that in 2023 would be at least $1,500 as the minimum deductible. Anything over that would be considered a high deductible, or $3,000 for a family. Now, 51% of the US workforce in 2021 were actually enrolled in a high deductible health plan. This is where the problem comes in with many of these programs that are being rolled out. Now, we did a patient survey with several other chronic disease groups that we shared in early 2021 that chronic disease group patient survey, they answered 55% were on a high deductible health plan. Now, in 2021, if you look at eHealth, they reported that the average deductible of a high deductible health plan is $4,364 for an individual, or $8,439 for a family. Again, max deductible in 2023 is going to be $9,100 for an individual, or $18,200 for a family. So the fundamental problem starts here. So many Americans are in a high deductible health plan, and these deductibles can be exorbitant, right? Now, I hear employers say all the time, well, they should have not chose a high deductible health plan. Well, many employees only have a high deductible health plan offering. That's what the employers offer, period. Others, if they get to pick, it's based on what they can afford. They can only afford what you're paying them minus all their bills. And oftentimes the high deductible health plan is going to result in the lowest premiums of what they can afford. And they don't understand how it directly applies to the highest out-of-pocket costs. So next, now it's also important, I want to make sure that you know the deductible must be paid in its entirety before the plan picks up the first penny. So think about that with these high deductibles. So we had the copay accumulators introduced where they said you can continue to use manufacturer or patient assistance from any third-party nonprofit. However, that assistance won't count to your deductible out of pocket. Now, it sounds like that's great because they're still allowing you to use the assistance. But if I'm a member and I'm on a high deductible health plan, and let's just say my deductible is $5,000, there's annual caps on assistance. So I could exhaust that assistance within the first couple of months, and then I am left to pay that entire deductible before the plan will pick up the first penny. And so, you know, when we know that the abandonment rate for drugs at $250 is so steep, imagine what it would be if it's $5,000 or more dollars. Next slide. Oh, I do want to also point out this is in direct conflict, so that they're not allowing the assistance to count to the member's deductible or out of pocket. But that's in direct conflict with the ACA's statutory definition, which says cost sharing means any expenditure required by or on behalf of an enrollee with respect to their essential health benefits. Next slide. And then we have the maximizer programs, and this is where they actually stipulate that specialty medications are not an essential health benefit. So they move these certain drugs, specialty medications outside of the plan design into a different program like Save on SP or Prudent RX. And they set the copay for those drugs mostly. Now we've seen some that are even higher, but most of them are equivalent to the max assistance that's available for that particular drug. So if the manufacturer offers $15,000 of assistance annually, then they would set that copay for $1,250. Here's where the problem comes in. The same companies that actually promoted the copay accumulators, it's important for you to understand the irony here. They said that copay accumulators should be implemented because patients don't have any skin in the game. Patients circumvent plan design with an accumulator, and they don't have to worry about what anything costs. It's not fair to other employees, etc. These same companies started these maximizer programs, and these actually force patients to enroll in the assistance programs. So in the case of a patient, let's just go back to an accumulator. If a patient has an accumulator on their plan, and let's just say they're one of the fortunate Americans who happens to have that $5,000 themselves. So comes time to get their meds at the beginning of the year, and they say, do you want to access any assistance to pay your deductible? And the patient says, no, I actually have my own $5,000. And the patient pays the $5,000 and they get their medication. And after that, they've met their requirements, met their obligation. And from then on, the costs are covered. Let's just assume that was also their max out of pocket. All costs for covered treatments or services would be covered at 100%. Now on a maximizer, if the same patient says, I don't want to enroll, because they're forcing patients to enroll in the assistance programs in this case. So if patient says, I don't wish to enroll in assistance, I have my own $5,000, I don't want to help create any further problems or burdens to the system, I'll pay my own $5,000. Well, not so fast, because you won't be just paying $5,000. You're going to be paying for your drug equivalent to what we've set the new copay at. So in my example of $15,000 or $1,250, a member would have to pay the $1,250 every month for the entire year without any max out of pocket, and that does not apply to the member's deductible or max out of pocket for the plan. So that is where I have a problem with, we have a problem with at NHF, but also, as you heard Dr. Feldman say, it's the issue with saying that specialty medications are not an essential health benefit. Next slide. And then we're seeing companies and in this case, Cleveland Clinic, who also offers a health plan, give a presentation at PBMI that this is the savings they realize from cashing in on manufacturer copay assistance. So they're trying to make it look like it's all the patients receiving the benefit, but it really is a money maker for these health plans. So in this case, they showed in 2019 where they got almost $9 million in additional savings that they took advantage of from the manufacturer assistance. That wasn't helping the patient, by the way. Next slide. And then we run into alternative funding programs, which which evolved from the whole idea that specialty drugs are not an essential health benefit. And the alternative funding programs, they target employers. At first, they were targeting employers in certain vertical markets because they knew that there is income eligibility requirements for patients to access that free drug or patient assistance drug. And so they were targeting industries that had lower wage employees. And so they could have a greater success at getting them approved. So they were sending their members of these plans notification that your drug or all specialty medications are no longer covered. They're considered non-essential health benefits, so we're no longer covering specialty medications. But have no fear, we have one of these companies, and there's now some 23 or more companies doing this, that is going to do a white glove concierge approach and help you get your drug at little to no cost to you. And they do it by making the patient sign a power of attorney over, and they act on the patient's behalf to try to access the free drug. The second option and the newer way they're doing it is through Magellan and other organizations are not excluding. They're not sending the member a notification that they've carved it out. They're excluding it at point of authorization. So I'm going to go through these two with you quickly. So the first, next slide, please. The first is carving out specialty drugs. So that's where the member receives a notification beginning on this date, we will no longer be covering specialty drugs. So the plan notifies the member that specialty drugs are no longer covered, but that there is an alternative funding vendor that they have contracted with who will be making contact with the patient. They require the patient to sign a power of attorney. If the member refuses to sign the power of attorney or engage, their only option is to self-pay for the drug, the entire cost of the drug, no out-of-pocket meds. If they go ahead and engage, which that's the only option anyone would have, let's be honest. So they would sign the power of attorney, then that company would act on behalf of the member to apply for the manufacturer patient assistance program. And while they're waiting for the manufacturer patient assistance program approval or denial, then they take advantage of the manufacturer copay assistance. The patient then receives either, they're told based on their household eligibility that they're approved or they're not. If they're approved, then the patient would start to receive the free product from the manufacturer, which has been pointed out in the chat. And I think it's important to note, those free products programs that every manufacturer has are meant as a stopgap solution for the most needy of patients. You lose your job, you change jobs, you're in a gap period on your insurance, and the manufacturer steps up to make sure you are able to still get your drug. This is not meant to be in perpetuity, we're giving drugs away free. Not one person on this call is in business to do that, including us as a nonprofit. So they either, the member receives the drug for a specified period of time. This alternative funding vendor then says that we'll keep track of when it's going to need to be renewed, and they'll renew on apply on behalf of the member. If the member is denied at the point of authorization, then the plan sponsor can either do a medical necessity override, which we saw most of the time if they weren't approved. But in some cases, they said it's self-pay or nothing. We don't know what to tell you. So this is a really dangerous situation. And again, we talked about, I love that Ashira brought up the section 105H, I believe, and the discrimination in those who have and have not in this situation. Next slide. So now the newer kind of strategy we've seen over the last 6 months, and what I told you Magellan started, is they're avoiding any exclusionary language. So the member is not actually even notified that the plan has implemented an alternative funding program. Instead, Magellan acts as the prior authorization agent. Magellan is partnered in the case that we found with Paid Health and with Care Factor as the PBM and the alternative funding provider. So medication, they're never notified that this has happened. So it's time to get a new prior auth for the year. They call Magellan for the prior auth and Magellan immediately denies. And at that point, when it's rejected, the alternative funding vendor makes contact with the patient and requires the patient to sign a power of attorney. And then the steps again follow the same steps. If the member says no, its only option is to self-pay. Member will not say no because nobody can afford these medications on their own, we're being honest. So they're going to then go through the manufacturer PAP program. And if it's approved, great, they get the drug for a period of time. If it's not, then it's resubmitted. This is in Magellan's word, resubmitted and paid as a pharmacy benefit. So it's a false exclusion. It's actually, in my opinion, I don't know how it's not illegal, taking advantage of the manufacturer assistance programs, but it's actually causing these manufacturers to now make their criteria far more stringent. And so those people who are truly needy, we can't get them in these programs. So it is a big concern that we have. Next slide. So these are the companies that I found to date. I'm sure there are more. Certainly, if you know of more that I didn't include, please include it in the chat. But these are companies that have specifically targeted offering these alternative funding solutions. It's not all about the patient assistance program. That's the first option, is to try to get the free drug. Then we're seeing, as you've heard from Ashira and Madeline, we're hearing about them saying, okay, if we can't get that, we'll try medical tourism or drug importation, or we'll try the copay assistance program. So to be clear, as NHF, we have a huge issue with the idea of drug importation, considering that for us, the drugs are biologics, and the National Benefit and Payment Parameters final rule that was issued this year from HHS said that the only when a state and an entity has been qualified, would they be able to import, which to date, I don't know of any that have, but it could only be from Canada, and it could not be for any drugs that were that were infused like our drugs are. And it certainly, that would exclude us, but it would also not be for any biologic products as well. But our patients are being offered trips to other countries, far and wide across the globe. We'll send you here and we'll get you a year's supply. But as you heard Ashira say, even if a patient self-imports, it's limited to 3 months. It can't be for a serious condition. All of these violate those rules. And we don't know where that drug comes from. Let's be honest, this may not even be the real product. We have no line of sight as to whether it's been managed properly, whether it's been cold chain stored like it's supposed to be. And so for those reasons, we are very against the idea of any of these type of programs. Next slide, please. And so here's, organizations, Concordia University. This is just a couple of many, where a member gets notified that if you're on a specialty medication, we no longer cover these drugs, but have no fear, you're going to be getting contacted by this organization, and they're gonna, in this case, it's Payer Matrix, and they're gonna walk you through the process of getting your drug covered just in a different way. Next slide. And in this case, a cystic fibrosis family spoke to their HR director about the decision to go with this case with SmithRx. HR director said that SmithRx came up with a group and told them nothing would change for the member. They would exclude expensive medications from the plan, but the families were guaranteed to get their meds at no cost if they went through these manufacturer assistance programs. They can't guarantee anyone's getting the medication, let's be clear, because you have to go through an authorization process. And they said that they would, if in case that they didn't qualify, then they would work to get them a medical necessity override. Next slide. And sorry, these are coming up so small. This was a memorandum from a school. Same thing, their employees received notification that they had implemented this program, no longer covering the specialty drugs, and that they would have to go through this company. Next slide. And I just want to real quick go over the consequences here. So there are unintended consequences and concerns we've had. I've mentioned a few of them, but the fact that for us, patients infuse intravenously, most patients infuse intravenously their medication, or it's a subcutaneous injection. There's one product currently on the market for hemophilia that's a subcu injection. They have a lot of market share as well. I will tell you that when they get the free drug from the manufacturer, there are no infusion supplies. Patients cannot just go to their local Walgreens and buy port sterilization kits, butterfly needles, saline, and the various supplies needed to intravenously infuse. This is a problem. They are in cases where they are getting the supplies somehow to go through as a claim and charging the PBM. We've seen the PBMs try to claw back the claims and go after the patient for that money because they didn't get to dispense the specialty medication. Timely delays, huge delays in many cases where we've seen patients waiting for their approval, sitting there with no medication as they are trying to get this scheme passed through. And then we've seen actual HIPAA violations happening where the folks from these alternative funding companies send a letter to the employee and the employer listing the medication, et cetera, which is in many cases, patients don't want their employer to know specifically exactly what medications they're on for their health conditions. And then offering these alternative importation and medical tourism offers that I've already shared my concerns on. So, you know, we've had patients that have to go to the hospital as a result of waiting or because they don't have the needed supplies to infuse. And that's going to end up costing the plan more because obviously that's the highest cost of care setting. So I'll stop there and answer any questions. Thank you.
Thanks so much, Colette. That was really helpful and really, I think, comprehensive on all the problems that these programs cause for patients, especially in terms of, you know, even if you're getting that supposed free product, no, you're not having the supplies to administer it. And so that just raises more issues for you once you have the medication, how to administer it. And I know this is a lot of information that we went over, but like, just think of how much information this is a process when you're newly diagnosed with a condition and trying to not only manage your condition, but also manage how these programs are working. So now we have a couple minutes left, so I want to open it up to the Q&A portion. I did see a question in here of if we are seeing these in non-ERISA plans, and the answer is yes, we have seen them in large group plans, which are regulated by which can be regulated by state law, but we're also seeing them in ERISA plans. Let me see.
I did see one, Ashira, that was asking basically, if not this, then what? How do we afford these things? And I just sort of want to throw out there, particularly when it comes to the infusible medications that rheumatologists use that are all very expensive. We have looked at how much it costs when you directly contract with the physician versus getting it the usual way through the PBM, even through their specialty pharmacy. And we have found that often directly contracting with the physician, it is actually a lower cost for your employees. However, you never actually really see you never really see the real price when it's gone through the specialty pharmacy versus going with the physician. CSRO is actually trying to put together not only this toolkit for employers to help them try to figure out how to afford the medications that we give and infuse, but also to see if there's any interest in directly contracting with the rheumatology offices. And I'm sure this can happen with other specialties as well, to try to lower the cost overall, because the administration fee is small compared to the price of the drug. And if we can get the price of the drug down, I just want to say there are alternative ways to work with the physicians directly to help lower costs for your employees.
Yeah, can I?
That's
also
great. Go ahead.
I just want to real quick add, I think to build on that, Dr. Feldman, is that, you know, at NHF, we've been working with payers, self-funded companies, as well as large plans across the country to try to help them mitigate cost risks associated with hemophilia. We recognize we're high cost, and we said, let us, you know, open the kimono and share best practices to avoid, and there are ways to drive significant savings without doing one of these schemes. But I did want to point out that I had reached out to Lauren Bella, who was previously with Purchaser Business Group on Health, and then most recently with Walmart. And she said, you know, there is, with the CAA, I'm sure those on this call are aware, the Consolidated Appropriations Act that's being implemented, that there is an obligation now for employers to become interested in how the way they manage drug spend might impact the employee's health. And so I just want to, I know we didn't go into that part of it, but leave it with that as a consideration, because that onus is now on employers, including ERISA employers, who have to attest that they are looking at these things. So thank
Great.
you.
Thanks for flagging that, Colette. And with that, I think we are at time, but I want to thank both Colette and Dr. Feldman for taking the time to participate in this webinar today. Your insights are incredibly helpful. And thank you to all the attendees today. And there's my email. So if you guys have any questions or follow up, feel free to give me an email, and I'm always happy to have further conversations about these issues. Thanks so much, everyone.
Thank you so much for having me.
That's so great. Thank you to all three of you, and to AIMD Alliance, and to all of you for attending. If you happen to have come late, no worries. This has been recorded just now, and we'll have it archived on hr.com later today. So just check back with us. As well, your HRCI and your SHRM credit, those will appear in your account within a couple business days. We'll also send you an email with that information. And then just note as well, above the great comments, I put a link to an exit survey in the chat. However, as soon as I close out the session, it's going to pop open in a new browser on your computer. So your feedback is so important to all of us. And so just take a brief moment to fill that out as soon as you can, and have a wonderful remainder of your day, and stay well, everyone. Take care.